Okay, it is about 8:32 p.m. Central Standard Time, and it is Tuesday, June the 15th, 2021. Welcome to week number, anybody know what week this is? This is week number 6. Week 6. I told you it would be here soon. Well, you know it. I warned everybody. Get those assignments in. I remind students that the rubric is very important. I follow it quite well to set up the outline for most of your grading. And those of you who got lower grades didn't satisfy the rubric, such as your papers may not have been the length that it requires, or not many of you got Grammarly hits, but it's very important. And I had someone reach out to me about the rubric today. They said they couldn't see why they got a certain grade and why I had to override it. It's because of the fact that the rubric doesn't allow me to change the numbers, but I changed the numbers with my comments. And then at the top, I'll subtract the points. Now, by overriding the actual grade. Now, where you find the comments is in the rubric in the grade book. Some students look for the rubric, the general rubric. No, because that would show everybody your grade. No, your own grade book, you will see that the comments as to what you did wrong. So I am all up to date on my grading. Week 5 just finished being due Sunday. So I'm working on that. And traditionally, I usually get week 5 and week 6 done. Well, obviously, because your final grades will be due a week from yesterday at 11:59 p.m. Central Standard Time. And then you'll be on a break until we are anyway, until the 6th of July, that Tuesday in July. So let's go ahead and get started, and let's share the screen, talk about what we have to talk about. All right, so here we go. Share my screen. Here we go. And there it is. Let's move this one out of the way. Put it here. Let's go to the student preview mode. And let's take a look. First of all, to remind you, emails. These are all the emails that I sent out this term, with the PowerPoints for week 6 being the very last email that went out to you. And you should have that as well. And then also you see the PowerPoints for and recorded lecture links, even though your recorded lecture links are in the module itself. Let's take a look at the assignments for week 6. And for this week, you don't have a written assignment. So your last written assignment was completed Sunday. And so we have just a quiz and then the live classroom lecture. So week 6 for you guys. Remember, the quiz for week number 6 covers which modules? And I'm going to just ask, what modules does the quiz for week 6 cover? That's right, 4 to 6. So the best thing to do to get ready for that is to go back, and you don't have to look at module 3s. Look at module 4. I would look at those practice tests. I would look at the PowerPoints. Of course, you will have done your assignments from weeks from 4 to 5. And then finally, um, listen to what I say in the lecture today. That will prepare you for the quiz. You already know how it works because it's the same kind of quiz. And I said this before. The questions that are going to be included in the quiz for week 6 are going to generally be found in the modules 4, 5, and 6 with your practice tests and the things that are in there. They may change them a little bit, but they are there. But again, you don't overthink them. Just make sure that you know the terminology as well. So let's look at the discussion. Murder or self-defense. And so you're going to consider this scenario. And in your initial post, which is due tonight, the 15th, question, will the clerk be able to justify self-defense? Explain why or why not. Identify a self-defense statute in your state or another state and explain why the elements of self-defense have or have not been met. That's it for your discussion post. Again, your initial post is due on Tuesday. Your reply post, examine another student post that may contrast with yours. Defend your position regarding both posts. By the way, when is the reply post due? When is the reply post due? Yeah, it's right there on the screen. Participate by the 18th. So yeah, it's all over the place. Not the 19th, which is that Saturday. Nope, you will not get points for that. So that's your discussion assignment. Pretty straightforward. I'm not going over the quiz because I'll show it. You'll see it. And then your live classroom lecture that I will be giving you as well. Okay. So now let's look at the calendar for the last time. I like the month view, and you can see where we are right here. This is where we are, your initial post due, and then your live lecture, and then this is what's due on Friday. Of course, the course ends. If you were to click on that, it would open it up and it would tell you. And if you clicked on that further, it would say it's the end of the course. Okay, but I like to do the month view. So you have your discussion post reply, then your live lecture phrase, and then your quiz. That's it. Course is over. 11:59 p.m. Central Standard Time. Now, it's very important. Do not submit to me anything after 11:59 p.m. Central Standard on Friday because it will not get graded. Your final grades will be submitted by the 21st by 11:59 p.m. I too have the same rule you do. I can submit them on the 22nd. They sometimes give us a break there if there's some extenuating circumstances, but they're pretty serious about the 11:59 p.m. Central Standard Time for us as well. So by the 21st, you'll know what your grade will be in this course. Okay. So now, here, let's go back to this. Let's take the announcement. Here's the announcement again for week 6. And let's move this Andrew out of the way here. So this week, defenses to criminal liability will be presented. And prepare for this chapter 10 of the textbook and complete the activities, mental disorder, insanity defense, which we're going to talk about, involuntary intoxication, mistake of fact, mistake of law, then self-defense. And then we'll deal with the practice for the key terms for practice, mistake of law, and then the last practice quiz. I already told you about the rest of this, but I'll repeat it again. Your discussion assignment is due tonight for your initial post, and reply post due by this Friday. And then the quiz is your written assignment. Of course, you know your other point was your key phrase or key word, which students that come to the live lecture have a head up on that. They can get that out of the way right away. So my reminder in bold print, typed, in case you don't listen to me, it says in the announcement, it officially ends 11:59 p.m. this Friday, June the 18th. Please complete the end of quarter student evaluations. I appreciate reading them and letting me know how you feel about the course and about me too. I like, well, anyway. Be strong and finish strong. Finish strong. I say it all the time. You'll learn that my motto is adversity is the springboard to success. Very, very, very important. Very important announcements. Okay. And that's the week's announcement. Okay, let's close that up. And let's get out of the student preview. Let's get out of it. Now let's go back to the regular. Okay, here it is. We already covered this. Let's move that up there. We dealt with the discussion, the quiz, the live classroom recording. You'll see the link that'll be placed here after I replace this, after I finish the recording. So now let's talk about these 4 areas here. First of all, let's talk about what is the insanity defense. First of all, let me say something to you up front about the insanity defense. I practiced law from 1978 to 2000 full time. And I started slowing down in about 1999 and then, 2000, but I still kept up with it. I had no success with getting a client to be found insane, even though I had some instances where it happened. But as a defense lawyer, my job was to always submit a motion to request that there be a psychiatric examination of a client when I thought that they would fit the mode, because that would be neglect on my part. But every time the psychologist would come back and say that the person may have manifested or demonstrated poor judgment or did some really wild things. However, the results came back that they were fit and they knew what they were doing. And so one of the things that you should be aware of is that the insanity defense is rarely able to be successful. The number of people that I know, for example, John Hinckley, the guy who um, shot President Reagan and then wounded the secretary, one of his, I think it's his Secretary of State, Brady, and then a Secret Service agent by the name of Terrence McCarthy, who was up until recently the chief of police in Orland Park, Illinois, but and spend most of their life in jail or in the hospital, even after that. And then there was a lady by the name of Amanda Wallace. We'll talk about her in just a few minutes. But anyway, the point of the matter is that insanity defense is what we call an affirmative defense, just like self-defense is. When it says affirmative, what it means is that you admit that you committed the crime, but that it simply means that you're excused from the crime by the actions that you were involved with because of your mental state. So, can you hear a dog barking? Do you hear a dog barking? Oh, that's interesting. Headsets are good. They drown it out. That's my dog is barking upstairs, and I can hear him like he's in the room. But most of the time, it doesn't come out in class. So, but anyway, so it is an affirmative defense. And so, as it says here, when someone is charged with a crime, you presume innocent until it could be determined that you're guilty beyond a reasonable doubt. Now, that's what it says in writing. In reality, we always say it's really the opposite. You presume guilty until proven innocent. That's the way the mindset operates, but that's a whole nother discussion. But if a person admits they committed the crime, and it's beneficial to do so, and they admit it, and so they use the affirmative defense, which is a justifiable defense or an excuse defense, and mental disorder is one. Now, there are three tests that we're going to talk about concerning the insanity defense, and it is allowed in most states, except Idaho, Kansas, Montana, and Utah. I think some of those states have changed that though. But notice what those other states do allow is that for guilty but mentally ill verdicts. So that means that you're found guilty but mentally ill. And so those people don't go home. They go to the same place people go that are not guilty by reason of insanity. That is a mental hospital for treatment. So anyway, let's talk about the three tests. These are things that you need to know for your test, for your quiz. The Norton rule is the first one. That's how it's pronounced. It's pronounced as Norton. The M is silent. And it came from England, like much of our law, except in one state in the United States, and that's Louisiana. They got the French Napoleonic Code. So under the Norton rule, you're not guilty by reason of insanity if at the time you commit the crime, you have what we call a diseased mind that prevented you from knowing the act of wrong or right from wrong. It's called the right-wrong test. So in other words, that the disease blocked your capacity to know right from wrong. That's basically what it means. For example, it says that at the time of the murder, the defendant thought that he was stabbing someone with a knife, that when they were stabbing someone with a knife, they thought it was a straw. Or at the time of the murder, the defendant knew they were stabbing someone with a knife, but for any reason, as a result of their mental condition, they thought nothing was wrong with what they were doing. So that's it. Probably one of the most common ones that you're going to hear about is someone who's delusional. And I'm not talking about somebody who's high on drugs. I'm talking about someone whose mental state is such that they don't know the difference. It's almost like a baby type thing. And so the Norton rule, for example, in the state of Florida, um, it can be established that the defendant had a mental infirmity, and because of that condition, they didn't know what they were doing or could appreciate the consequences or knew what they were doing was wrong. So that's the right wrong test. So how do you remember this? The Norton rule is the right wrong test. Okay, that's how you can remember it. Think of it like that. The Durham rule, you don't even have to worry about it so much because it only applies in one state, New Hampshire. And it's the product of mental illness tests. And it was established out of a case in 1954, Durham versus the U.S. And it kind of, uh, how should I say, uh, did away somewhat with the right wrong Norton rule, saying it was too simple. But listen to what happened. So it says mental illness is more complex than right or wrong. I agree with that. But that some of the actions would be the product of mental illness. So the Durham test is more liberal than the Norton and stretches the purely intellectual question to this. This is it. Did the defendant know the difference between right and wrong? That's it. So wait a minute, Professor, didn't you just say that that was the Norton rule? Yes, but if you remember, there were other things that were involved with the Norton rule, but they only take one part of it and the right wrong. You don't really have to worry about it too much, and really don't have to worry about it for the test because it's only in New Hampshire. If you were taking the bar in New Hampshire, you probably want to know this one. The substantial capacity test is different, and it did away with the recognition of Norton altogether. Uh, you know, right, wrong, but rather spoke in terms of the mental disease or lack substantial. That's a key word, substantial. If you run across that, we already know which test is going to apply. Either to appreciate the wrongfulness of their conduct or to conform to the requirements of law. An example of the substantial capacity test can be found in this Wisconsin statute. Listen to this. I'm going to read it. A person is not responsible for criminal conduct if at the time of such conduct as a result of mental disease, keep going, or defect, the person lacks substantial capacity. There we go. There it is. Either to appreciate the wrongfulness of their conduct or to conform their conduct to requirements of law. So substantial capacity is in there. The answer is given there. All right. So be aware that whenever test that you're under, when a person is proven successful in their insanity defense, they don't get a chance to walk out of the courtroom and go home. They are then sent to a hospital, and they remain there until they're physically fit. So the bottom line is that they're still going to be incarcerated. Now, either the judge or the jury, in some instances, render a decision whether or not the defendant is insane or competent. Now, be aware that they're guided by experts that testify and all of that stuff. So, again, the point of the matter is mental. You're sent to a mental facility, a mental health facility, until no longer dangerous. Now, I talked about Amanda Wallace a few minutes ago, so let me elaborate on that. Amanda Wallace was a young lady who, here in Illinois, I had a chance to see her in person. She was not my client, but she was all over the news. And you could Google Amanda, Amanda Wallace, and you'll see what I'm talking about. Well, Amanda Wallace had her child taken away by the Protective Services in Illinois, which is called the Department of Children and Family Services, or short, DCFS. And so they're always doing something really wacky. They're not too good with protecting the children. So at some point, they returned the child to Amanda Wallace. Shortly after Amanda Wallace got the child, she hung the child. She thought she was slaying a pig or an animal or something, and the child died. But she was really, really gone. She wasn't faking it. I saw her when I went to visit one of my clients um, when I was practicing back in, it was probably late 90s or early 80s, late 80s and early 90s. So anyway, Amanda was sitting in a corner and she was just rocking, and you saw her and you could tell that something was really going on with this person. She was out of touch. And so that's the way she was at the time that she committed the offense. So we always tell people that in order to get someone um, on successful with the defense, self-defense of insanity in Illinois, we use the Amanda Wallace test, that you have to really be way out, zoned out. Okay, let's go to the next topic: involuntary intoxication. Did you hear me? I didn't say voluntary, involuntary. And in other words, it's a defense if it's not voluntary. You cannot drink and then become intoxicated and claim intoxication as a defense. It has to be involuntary. And I'll tell you some examples of that. But if you read the statutes, it's determined that it's affirmative defense to a specific intent crime, which means that you had to have intent to commit the crime, not a strict liability crime, by preponderance of the evidence. So it's like in a civil case that that person voluntarily consumed, legally obtained and properly used medication or substance and did not know that, and reasonably could not have known that it would have caused him to be intoxicated or impaired. So that's it. Now, there's an argument made with most medications. I know that even the simplest of medication that I take for my blood pressure, amlodipine, it says in a warning on there, it could cause drowsiness. But that is a disclaimer from the lawyers who want to protect people. But to be honest with you, it really never had that reaction on me at all in all the years I've taken it. But the fact of the matter is that there are some things, like for example, you can take an extra dose of the medication, and then that's an involuntary intoxication. Okay, so uh, here's another involuntary intoxication and problem. And intoxication, one of the commons is when someone slips what we call a Mickey or spike your drink. I know some people that happened to, and it didn't even have to be alcohol. It could be a soda where somebody dropped something in it, and um, or unforeseeable reaction to prescription medications. Uh, then you can find that there's a defense. Here's a scenario: a fellow classmate, a college student has been up partying all night, but has to take which by the way is not advisable, take the test the next day and doesn't want to fall asleep in class. So the classmate offers him a white pill, tells him that it's a caffeine pill and it'll keep them awake. But they lied. And so the person relying on that took it, and it was actually a prescription methamphetamine hydrochloride chloride pill, and the person had an adverse effect, and they went into panic and went into rage, started acting wild. And so because this was involuntary, and all the actions they did, like broke windows, destroyed merchandise, then the defense that that person could use is involuntary intoxication. And so that's how it works. That's it. That's it. Don't think any more deeper into it than that. Mistake of law and fact. Mistake of fact means what it says. When someone commits a crime and some fact that negated the element of the crime. Uh, a person is not relieved of criminal liability because they engage in such conduct under a mistaken belief, unless the mistake negates the existence of the mental state by the person. Okay. Consider this example. Lisa is making a large person of goods. She's push more in a large box, which is at the bottom of the cart. The top of her cart is filled with a lot of items. While paying for her items, she's distracted by her phone and doesn't necessarily notice that the clerk did not ring up the item that was on the bottom. So she pays um, um, for her items. Then as she leaves, she's stopped by the loss prevention officer, who says that you didn't pay for the lawnmower, and calls the police and requests that she be charged with theft. Well, Lisa would say, "Oh no, I didn't mean to do that. I didn't know that. I'm sorry. It was an error on my part." And she had every intent at that time to pay for the merchandise, but the clerk neglected to scan the lawnmower. Well, that has happened. I remember I used this example, and it's not as the same. I ride one of those little electrical car things around Walmart when I go there, because it's such a huge store. And my wife gets these little drinks, the little I forgot what they're called, but they're sugar-free drinks, and they're different flavors. So anyway, I realized I had left my wallet in the car. And so anyway, I said, I'll be right back. I'll go get my wallet. Well, I got outside the door into my car, and I looked down, and there was one of the bottles. Well, it hadn't been rung up. And so I said, "Oh, wow." I said, so anyway, I went, took it back in, and I told the lady, I says, "I'm sorry, this was in the cart. You didn't ring it up." And she said, "Don't worry about it." But here's my point. If I had been stopped by the security people and then said I was trying to steal that drink, my defense would be, "No, I'm sorry, I didn't realize it was in there." And that would be it. That's what we call a mistake of fact. That's it. Pretty straightforward. Mistake of law is also pretty easy. And it gives some scenarios. Mistake of law can be used when a law that was later found to be unconstitutional is applied, or a person acted in good faith consistent with a judicial opinion, but it was misapplied. So remember, it was judicial opinion. They relied upon the judicial opinion. Person acted upon the advice of a person or agency responsible for administering law, like a law enforcement officer. A person committed an act contrary to law that is not yet published, not known that it's illegal. Okay, those kind of things. So those are the main things, and the statute in North Dakota kind of lays it out. So here's an example, and then I'll be done with this. Is that Paul, who was driving on a suspended license, and he wanted to drive his ATV to work. So his mother contacted the sheriff, and the sheriff's deputy was asked if he could operate his ATV even with his license suspended. He was advised by the sheriff deputy, yes, because it was okay. So one day on his way to work, Paul was stopped for speeding on his ATV and cited for operating with a suspended license. He was convicted when rendering, the court found him guilty. He appealed his conviction and it was overturned. And the reason why it was overturned, for the mere fact that the appeals court said that the trial court erred and should have considered the statement of the deputy sheriff. Paul only drove the ATV because he was given advice by someone of authority, a deputy sheriff charged with enforcing the law. That's like the third one here, that's up here, and those kind of things. All right, so remember that. Any questions about either of this section? Okay, pretty straightforward. And so we conclude with the final section, which is self-defense. Self-defense is a law that says that you can commit a crime ordinarily, but that you have justifiable reasons for doing so. And it's very important. So let's talk about the general rule of self-defense. We won't, in a little bit, we'll talk about the stand your ground. But at common law, the burden of proof is upon the person. So in other words, you admit you committed the crime, okay? But the thing that you must do is this: you must use the same amount of force that's likely appropriate to stop the unlawful interference, but doesn't go beyond that. In other words, once the unlawful interference is stopped, the force must also stop. So let's consider Bob walking on the sidewalk, and his girlfriend, Margaret, and they're approached by a drunk man who threatens to punch Bob. Bob attempts to avoid the conflict and tells the man, just keep walking. But he shoves Bob, and Bob draws back his fist to hit him and punches the man in the face. He falls to the ground. Bob's further upset because the man tried to assault him, jumps on top of the man and beat him until he became unconscious. And Margaret pulls him off. So be aware that the question is, was the force initially used by Bob to stop the intoxicated man from hitting him legal or justified? The answer is yes. But when he got on top of the man and beat him, it was unnecessary and it went too far. Okay? And the state of Illinois defines justifiable use of force is, now listen to this, this is pretty standard for everything. A person is justified in the use of force against another when and to the extent they reasonably believe that the conduct is necessary to defend themselves or another person from use of imminent force. However, now we get past that to using deadly force or great bodily to cause great bodily harm if reasonably believe that such force is necessary to prevent imminent death or great bodily harm to that person or to someone else, or commission of a forcible felony. So that's the way it works. Now, um, it's apparent that Bob's initial use of force was justified, but when he committed great bodily harm, it was unnecessary. It wasn't necessary. It wasn't one of those situations. So what does that mean? Let's say, for example, if I come at you with my hand raised to hit you, and you take out a gun and shoot me or stab me, and you're saying you were defending yourself, would that be considered justifiable, yes or no? Would it? No, absolutely correct. Because then you have gone too far. It's excessive use of force. And incidentally, that applies to law enforcement as well. Law enforcement is held to that standard as well. Law enforcement officers have to use the necessary force to protect someone. So excessive amount of shooting at someone can get a law enforcement officer in trouble, as some have already found out. And that's when we get into the violence. So now most states, most, uh, don't require persons to retreat before using self-defense. This is known as stand your ground, okay, which doesn't require a person to retreat, presuming they were not engaged in unlawful activity and have a right to be the place where the attack occurs, before using force to stop unlawful interference. Therefore, individuals cannot assert stand your ground if they are committing a crime when they are attacked. Also, a person cannot claim self-defense in cases where they provoke the attack. In contrast, some states will not permit self-defense claim in instances where the person attacked could have avoided using force, which is commonly referred to as a duty to retreat. So the stand your ground issue was a big issue and came to the forefront in the Trayvon Martin case. And I, believing all the facts, that George Zimmerman should not have been able to use the stand your ground, because he was told don't approach this young man. And it turned out that he didn't have any weapons or anything like that, but that him taking the life of that young man was not stand your ground, but a jury decided otherwise. And so it became very well known as the famous stand your ground case. I would call it a misapplication of it from a legal perspective. The battered women syndrome, a woman or male who has been constantly abused by their domestic partner to the point that they constantly fear being tortured or battered by their spouse, even if they don't, because of the many years or months or days or hours that they've been attacked in the past, form a mental condition that's called battered women's. Now, it should be battered person syndrome now. And it's used in domestic violence, if you study that, in the cycle of violence. And it is self-defense that a person would be able to protect themselves and use that as a defense for killing someone. All right. And so here's an example right here. Diane has been physically abused and battered multiple times by her husband, Jim, for the past 10 years of marriage. So just what I said earlier, each time it occurs, Jim's drunk, and that's when she is battered and been choked many times. One night he comes home drunk and they begin to argue over his drinking problem. Jim begins to escalate, and Diane, fearful that she will be substantially battered again, shoots Jim and is likely to argue self-defense in conjunction with the battered women syndrome and would probably win. Now, one of the problems with the battered women syndrome is that you have to be very careful about when you apply it. For example, I had a young lady that I knew very well. Her husband used to beat her all the time. He was a very violent man. And this is based on a real story. We grew up together. We went to high school together. I met her husband doing some real estate business, but I found out he was a very violent guy. Well, he used to beat her constantly, and she killed him. The problem is that she waited for him to go to sleep. and then she shot him and killed him. That is the problem that she had. But listen to me, good people. I believe that I could have argued, even though I didn't represent her, and I found out later, I read the transcripts, a jury would have said, forget all of that. Look at what he did to her. Look at the state of mind that she developed into. It's almost like the earlier instances we talked about, the mental state of insanity. This person's mind was so, they couldn't even think straight in terms of it. And so because of the fact that she did that because he had rearranged her thinking capacity on the way he treated her in the past. And she was not even logically thinking about it, and then killed him. Now, if she waited days and weeks and months, that's a different story. But that's not what happened to my friend. And unfortunately, she was found guilty and served time in prison. But the battered woman syndrome is very serious, or I use battered person syndrome in this day and time, because it doesn't have to be it's just a domestic partner. The castle doctrine, the castle is your home. It says that people who occupy their home can use deadly force to stop an intrusion. It doesn't matter. They don't have to, ask a lot of questions, but it doesn't require the person to retreat. It doesn't require the person to prove unlawful entry. It could think, just as long as they think they're in danger. And so deadly force is able to be used to stop the intruder. Unfortunately, what happens with this a lot of times is that it's not someone like that. It's an innocent member of the family or something. And that's what happens with usually guns. So the mere fact that the intrusion took place while the protected areas were occupied justifies the use of that deadly force. Okay. And you can read over this. And then finally, I talked about this already, about use of force by police officers, and I covered the importance that they have to use the standard that's commensurate with the crime itself. Use of force by police officers is common knowledge under the Garner versus Tennessee case, that you cannot shoot a fleeing suspect unless that person represents a danger or committing a violent offense. And the point of the matter is, it talks about the use of restraints and things of that nature. Obviously, a knee to the neck is not adequate use of force or restraint. We already know that based upon George Floyd, and we should also know about that because of Eric Garner, but definitely because of the George Floyd case. And so here are some things about self-defense and the Second Amendment you can take a look at. And that is it for me with the topics. Let's look at what I want you to do to get ready for this quiz, which is equal to your midterm. Know these terms. We covered them all today. Yep, every one of them we covered. Make sure that you be aware of these, because you will need to know them for the exam. Now let's do a couple of practice things. We got 8 minutes left, so try to keep you within time here. So let's do these. So Janie has a white cat named Snowball that wears a pink collar and is let outside every day. One day the cat doesn't return. A few days later, while out looking for her cat, she finds Snowball and brings her home. However, later that day, she realized that the pink collar has a tag with the name Princess on it. Jane contacts police, but she fears that she will be arrested for theft. This is an example of what? Exactly. Exactly. Mistake of fact. Because Jane didn't intend to steal the cat. Now, if she did find out about it and she decided to keep him after that, then in that case, that would not be the case. Okay. Eric waves down a police officer and asks, "My landlord locked me out of my apartment. Can I break in to get my stuff?" The police officer says, "Go ahead. It's your place." Eric breaks in and the landlord demands he be arrested for burglary. This is what? Yep, because he relied upon the police. Exactly. Yep. One more. Officer White is working a theft case and believes he has the right to enter without a warrant the suspect's apartment to retrieve the stolen items. Just to be sure, Officer White speaks with the on-call judge and explains to him. The judge says, "Go ahead and enter and retrieve the items," which he does. It's later determined that he violated the defendant's Fourth Amendment rights. So what would be Officer White's? Yep, yep, because he followed protocol. Now, of course, though, the mistake negates any unlawful entry that it may not be used, may be, thrown out on a motion to suppress. So the judge is an official. This negates an unlawful intent to enter, but it still could be used to not use that evidence in a trial. Okay. So then finally, the practice quiz is the end. Like what you'll see, you are defending a case where the defendant, Derek, is accused of killing his friend during a schizophrenic episode and believes he had to kill his friend because he was the devil. You don't believe that Derek knew the difference between right and wrong at that moment. What kind of test would be most applicable in this case? Absolutely, right and wrong. See, actually, the answer is given to you in the question, so you're correct. Yep. All right. David is hanging out with friends at a local bar. Somebody places an unknown liquid in David's drink. Your mind already should start to think now, which causes him to go crazy, strip off his clothes, throw objects through windows. David's arrested and transported to a local hospital. The next day, David has no recollection. What is David's affirmative defense? Yeah, and they should have said involuntary because it was involuntary um, because he wasn't drunk himself without that. Notice it says somebody places an unknown liquid. Yeah, like a Mickey or something like that, what I was talking about earlier. And the last one I'll do is what level of proof must be met in order to successfully prove an intoxication defense? What level? Yes. Some might say beyond a reasonable doubt. Don't say probable cause. Don't say reasonable suspicion. They don't apply in these, but it would be between these two. And so the answer is yes. A mere preponderance of the evidence. That's it. Yeah, 51% certain. So that's it. So you want to study those and make sure that you end up getting that information there. Okay. So that's it for that topic. So now I have to give you a key phrase, and the key phrase is self-defense. That's it. Give me self-defense. Put those points in. You know how to do it by now, and you'll get your points. Remember, they have to be in by 11:59 p.m. Central Standard Time Sunday. You can put them in right now uh, if you want to, and you'll get your points right after this. Well, I'm going to wrap up by saying it's been a pleasure to have been your instructor for the last 5.5 weeks, and hope that you learned a lot about criminal law, some things that piqued your interest, some things that may help you in the future. Someday when you become a criminal justice professional, you'll remember some of the stuff that I've taught. I've had a number of students who come back and told me that went into various fields, especially as law enforcement, that the criminal law class helped them a whole lot. But remember this course is not designed to make you a lawyer. It's just designed to give you a working knowledge of how criminal law operates and how the systems operate and work. There are always exceptions. That's the only thing about the law that's really exciting that I learned in my many years of being engaged in practicing and teaching. And so it's very, very, very exciting. And the foundational things have pretty much stayed the same. Like I said again, it's the interpretation of statutes by courts and juries as to whether or not a person commits crime, but there's some basic stuff that just kind of like leap out at you. So I hope I see you in future classes, not repeating this class. I will be teaching this course again, term 2 in the summer. And then I will be teaching drugs and crime also in term 2. But for term 1, starting the 6th of July, I will be teaching contemporary issues in criminal justice, which I see many of my former students in. And then I will be also teaching Introduction to Corrections, which is a course that many students have already had with me. You didn't have an Introduction to Corrections with me, did you, Andrew? Did you have Introduction to Corrections with me? Let's see. Yeah. Okay. Yeah, I've taught that course. And if you haven't had it, there's a good chance that you'll have me because I teach it quite frequently. So, all right. Again, it's been my pleasure. I always tell my students, if you need me, you know how to reach me. And even after the course, I have many students who come back to me even after they've gone to other classes and about to graduate. Hope you will get your associates, and then as many of my students have already come back and taken the bachelor's course. I teach some classes over there like constitutional law. I haven't taught in a while, but I love teaching evidence, so I'll be teaching that too. So with that, I'm going to say good night to you. um, Study hard. Remember, the final exam quiz is 4, 5, and 6, and I've already told you the best way to prepare for that, and you'll do well. Remember, it's closed book though, no notes or anything like that. All right, so I'll hope to see you guys further down the road. Uh, Enjoy your break, and again, take care of yourself and stay safe. Good night.